Okay. We'll hear argument this afternoon in case number 26-533, David Bronner, President of the United States petitioner, versus Mark Crosby, respondent. Petitioner ready? Respondent ready?
Yes. Respondent is ready, Your Honor.
You may proceed.
Mr. Chief Justice, Honorable Associate Justices, and may it please the Court. My name is Katsuki. Alongside my co-counsel, Mr. Joshua Wang, I represent President David Bronner, the petitioner in this case. My co-counsel will address the injunction issue, but first I'd like to address the Article 2 issue. Mr. Crosby was removed because, put simply, according to his boss, the president, he was not the right individual for the job. While Congress has attempted to insulate Crosby from removal, their insulation is in conflict with the Constitution and thus cannot stand. This court has significant precedent and a well-established procedure for determining which officers can be protected and which cannot. Chair Crosby falls squarely within that latter category. And the reason is simple. First, removal work protections are unconstitutional when an agency exercises executive power. And second, the Federal Reserve does indeed exercise executive power. To the first point of the removal protections themselves, the majority in the lower court relied heavily on the case of Humphrey's Executor versus United States.
Counsel, how can you say that there's no protection when literally that the statute that created the agency says for cause removal only?
Yes, Your Honor. My contention is not that Congress did not intend for protection to be in place, but rather that in an agency that exercises executive power, that protection cannot be allowed to stand by this court.
So are those words superfluous? Are those words like unconstitutional in themselves?
I would contend that their application, forcing the president only to remove for cause in an agency that wields executive power, would be an unconstitutional standard for this court to uphold, Your Honor.
But isn't that an infringement on the power of Congress? Congress creates the agency, and the removing for cause or not for cause, at will, that reflects how Congress is crafting the agency, right? So doesn't this infringe on their power?
I would disagree, Your Honor. While it does limit the power that Congress has, I would disagree that it infringes upon it. Congress has the power to create agencies however they like within the boundaries and constraints of the Constitution. If Congress would like to create an executive agency, it must do so while containing, or rather taking heed of the second article and the president's constitutional power over said agency.
Where in Article 2 are you resting this argument on?
I would go to the vesting clause that all executive power belongs to the president alone, as clarified in SELA, as well as the take care clause that the president must take care that the laws be faithfully executed.
So your statement that an agency exercising executive power cannot be protected for cause removal would overrule Humphrey's executor.
Not necessarily, Your Honor. I would turn you to the case of CELO Law versus CFPB, where this court has repeatedly and most recently in that case redefined the standard set forth in Humphreys and really constrained it to the point where that standard is no longer such an egregious constitutional question as it was at the time of that court's decision.
Does CELO law stand for the proposition that any executive power means that the agency falls outside of Humphrey's executor?
I believe it does. It was specifically in that case, the court wrote that Humphrey's executor, quote, permitted Congress to give for-cause removal protections to a multi-member body of experts balanced along partisan lines that was said to exercise legislative and judicial functions and not to exercise any executive power. Thus, the bright line they're drawing is that of any executive power whatsoever.
Is that an accurate description of Humphrey's executor? Surely the Federal Trade Commission's enforcement powers, its adjudicatory powers, even in 1914 and in 1930, in the 1935, when Humphrey's executor was decided, they exercised some executive power.
I would contend that that's true, Your Honor. I would say that that the precedent that was set in Humphrey's executor is accurate, while its application to the FTC may have been inaccurate. But in
Is there any agency in the federal government that would meet your test, your interpretation of the test in Humphrey's executor?
I would contend that it is. Based on the court's analysis in Humphrey's executor, they stated that the FTC was non-executive because instead of actually implementing its will on the private sector, it rather made reports and recommendations to both Congress and the executive. Thus, it was more of an investigatory body, not one that actually would penalize or enforce its will on the private sector.
Counsel, did the First National Bank of the United States discharge executive functions?
I would contend that it did not, Your Honor. Rather, it was a bank chartered by Congress and chartered by the federal government, but that exercised primarily quasi-private powers and regulated just like a very large bank would in the private industry.
Well, that's what we're talking about with the Fed, right?
I would disagree, Your Honor. I would contend that while the Federal Reserve does have some private powers, or rather powers that seem to be private, the majority of the Federal Reserve's actual power goes to direct regulatory function and executive power, not the same sort of quasi-private institution we saw in the first bank.
Could you just list for me the executive functions that the Federal Reserve carries out?
Yes, Your Honor. I think the most obvious are two. First is the idea of the stress capital buffer. That first falls under the idea of rulemaking, which was defined as executive under CELO law, and then goes on to clarify that it actually requires fines and restricts dividends and share buybacks on those banks if they fail to comply. That
Okay.
would.
So I know you probably have other examples. I want to ask you this. Suppose Congress passes a law tomorrow and the president signs it, taking away the list of 5 or so executive functions that the Fed exercises. Different result in this case?
I would contend yes, Your Honor, because the basis is on the amount of executive power that an agency wields. Its protection from the president is necessarily dependent on whether or not it exercises.
So if the Fed just did open market interest rate type, and this type of stuff that everybody thinks the Fed does, most people, let's be honest, don't know about the other things.
Yes, Your Honor.
If they did only that, they could be protected.
I would contend that they would show a much more compelling historical analog to the first bank, and therefore it would most likely be protected by this.
So then we'd end up with a fourth branch still.
Not at all, Your Honor. I would contend that wouldn't be a fourth branch of government, but rather a government-chartered private entity in that case. Mr. Chief Justice?
Oh, I want to hear how you transition to your next point, and then I had a question.
That is a great point, Your Honor. I was going to speak briefly on the only other exception to the president's removal power. That was established in Morrison versus Olson, which upheld removal protections for inferior officers. Chair Crosby.
Okay, so I want to ask you this then. Could Congress say, okay, fine, let's assume that the president has all hiring, firing power over everyone in an executive agency, because all the agencies are an executive branch, right? I mean, it's like the Librarian of Congress is separate.
Yes, sir.
But could Congress then say, okay, we're going to craft and pass a bill that create a Fed, a Federal Reserve, and that is inside the legislative branch, and then if the president vetoes it, they overrule. They go ahead and do the supermajority and get rid of the veto, and then they say, great, now this is how this runs. Could they do that?
It would depend on the powers of that agency. Rolled
Exactly the same as the Fed today.
Then I would turn you to Boucher versus Sinai. This court wrote, interpreting a law enacted by Congress to implement the legislative mandate, very essence of execution of the law. If this hypothetical agency were to do that, it would still be considered executive, I think, by this court, and thus would require presidential removal at will.
So your interpretation of all executive power, though, would also run contrary to Morrison versus Olson's protection for inferior officers, right? I don't think you have any way to avoid overruling Morrison versus Olson and Humphrey's executor under your interpretation of all executive power.
I would disagree on the Morrison versus Olson point, Your Honor, because in that case, we were not restricting the power of the president, but rather a principal officer who would have power over said inferior officers. Principal officers have not been granted all executive power under Article 2. Thus, restricting their removal power would not necessarily cause the constitutional concern that we see in this case.
So I want to understand why removal is an executive power under your interpretation of the executive power. The Article 2 goes to great lengths to specify the balance of powers in appointments between the president and the Senate, and it says nothing about removals. And shouldn't then we treat removals as a question not explicitly addressed by the Constitution?
No, Your Honor, I'd point you to Myers versus the United States, where it states that the first Congress debated extensively on this subject and found that because that traditionally executive power was not expressly taken away from the president, it necessarily remained with them. Thank you, Your Honors. That is all my.
Thank you, Cal.
Permission to proceed, Your Honor. Thank you, Your Honor. Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Joshua Wang, and I'll be addressing the reinstatement issue. See, the question before this court is not whether or not Crosby deserves redress, but rather what redress this court has the authority to grant. This court's responsibility is to interpret the law, not create or rewrite what Congress has already written. And unlike other agencies, the Federal Reserve was written with no provision requiring reinstatement of an officer who's been wrongfully removed. And to grant reinstatement, absent such a provision, would cross the line of this court's power. We therefore ask this court to reverse the decision of the lower court and to not reinstate Crosby. And we submit 2 lines of argumentation to prove this. First, that an injunction cannot be used for reinstatement. And second, that a writ of mandamus cannot be used for reinstatement in this case. First, the injunction issue. Now, injunctions come from persons.
Oh, thank you. Counsel, why are you framing this as a question of this court's power? Because it occurs to me that mandating the president to retain, as an executive officer, someone the president does not want, shouldn't we focus more on the president's power? Why are we focused on our ability to grant remedy?
The reason, Your Honor, we focus on this court's power specifically is because in order to grant reinstatement, this court must have the power to do so, whether from a court of law or from a court of equity. Now, we agree. There is also a large issue regarding the president even being able to enforce through a mandamus or an injunction as well. However, we believe the more pressing issue here is whether or not this court has the ability to order reinstatement, whether from a court of law or from a court of equity.
If we assume for the moment that we do, would it be constitutionally appropriate to require the president to have as an executive officer someone they don't want?
We believe that is a question of a lot of debate on whether or not this court has the power to specifically enjoin the president. And we would turn this court to Swan versus Clinton, in which the lower court decided and left the question up in the air of whether or not the president could even be enjoined in the very first place. However, even if this court were to rule that the president could be enjoined, this court doesn't have the power to enjoin the president. The reason for that is because courts of equity are historically confined by what was originally given to the English courts of chancery. And the English courts of chancery were explicit in not giving power for appointment and removal.
The courts of England worked for the king. There was no judicial branch. It was one of the reasons the Constitution was written the way it was, to create independence for the judiciary from the sovereign. So why should English equity practice guide us at all here?
Of course, Your Honor. We would turn this court to the case of Grupo Mexicano de Desarrollo y Alliance Bond Fund, when they write, "We do not question the proposition that equity is flexible, but in the federal system at least, that flexibility is confined within the broad boundaries of traditional equitable relief. And to accord a type of relief that has never been available before is to invoke a rule not of flexibility, but of omnipotence." The reason courts of equity must be confined to the English courts of chancery is twofold. The first of which is that this court and Congress was the one that established them and confined them. But the second reason is because courts of equity must be bound by some boundaries, or else it would have near unlimited power.
So what remedy would there be? I mean, if at the end of the day you say there is no remedy, well, that just can't be, because then we're allowing the president and no one else to, do something wrong and then have nothing happen.
3 responses, Your Honor. The first of which is that there is remedy. The most obvious which is back pay, which was given in Humphrey's Executor, Myers versus United States, and Wiener versus
But
United States.
that's not the injury. The injury is that they are entitled to complete their 14-year term. And I mean, maybe if you're talking about like the pay they would have until the end of that, but that's not all a job is.
Of course, Your Honor. We would turn this court to the case of Morrison versus Olson, where in that case, when Congress wrote the Office of Independent Counsel with a reinstatement clause, reinstatement can be given in the case of wrongful removal. But because the Federal Reserve was not written with reinstatement clause, it's not a power available. The conclusion that I'm trying to reach is that if the Federal Reserve was written by Congress, which can be done with a reinstatement clause in case of wrongful removal, there is a remedial option known as reinstatement in the form of mandamus because it's found within the law.
Oh, go.
No, you may finish.
I was gonna say, doesn't that conflict with what we were talking about with your co-counsel about how we look at, for cause, and we're going to say, well, that language, we're not gonna pay attention to that because we say it's constitutional, and here, look, all of our hands are tied. If we can change it one way, why not change it the other, especially in a court of equity?
We disagree, Your Honor, and the reason for that is because courts of equity have been historically confined and must be confined. And the English courts of chancery weren't exactly ambiguous or left it up for debate. They were explicit in saying these were powers not available. This is found in re Sawyer when they write, "It is equally well settled that a court of equity has no jurisdiction over the appointment and removal of public officers." Now, when it comes to a writ of mandamus coming from a court of law, there's a little more debate here. However, the same principle applies because the requirement for a mandamus is high and clear-cut as a ministerial duty. And to borrow the words of McLennan versus Wilbur, cited in NTU versus Nixon, the law must not only authorize the demanded action, but require it. The duty must be clear and indisputable.
My question is, what is the current status of the official in question? Is he a de facto officer?
De jure, he has not been removed, but de facto, he has been removed and requires reinstatement, Your Honor. And what that goes to show is that the only way for Crosby to truly have his chair back is for him to be reinstated, whether that be mandamus or from law. Yet a mandamus requires reinstatement to be found within the law, like Morrison versus Olson. However, because the Federal Reserve was written with no provision requiring reinstatement, it cannot be enforced as a ministerial duty.
Is your suggestion that this court's power depends upon what Congress writes in the statute? We have traditionally, and as recently as Trump versus Casa, reaffirmed that we have the power to do complete equity when the circumstances require.
Yes, Your Honor, this court has the power of equity, but when it comes to equity, which is notably different from a court of law and mandamus, courts of equity have to be confined. And the only...
So square this with Marbury versus Madison, and square it in particular with your vision of the unitary executive. If your vision of the unitary executive holds, then the courts can never enjoin any executive officer because they're essentially enjoining the president at the end of the day. But Marbury versus Madison quite clearly stands for the proposition that someone can't be, that the court should order reinstatement.
Your Honor, we believe the conclusion reached in Marbury is different from the facts at bar. And the reason for that is because in the case of Marbury versus Madison, the Secretary of State was asked to complete a commission that was deserved to be delivered, completed, and for the position to be given. In some sense, it was an action that needed to be completed, wasn't completed, and therefore could be enforced through mandamus. But in the case at hand, the only law that exists, the only action that should have been completed was for Crosby to not have been removed. Yet Crosby has already been removed.
So your co-counsel says we don't need to revisit Humphrey's executor, that's distinguishable. But under your view, given the limitations of our authority, your client, the president, can just fire whomever he wants. And once it gets to us, the only question is whether we award back pay. So where is the restriction and removability? Where's the viability of the restriction on removability in your world?
Not necessarily, Your Honor. Just because the president has the ability to fire at will doesn't mean the president can immediately fire at will. And we present two, remedial options besides reinstatement in this case. The first of which is the obvious one in which Congress can write in a reinstatement clause like Morrison versus Olson. The second of which is public approval, in which the president is directly held in check by the power of the people, whether that be through impeachment, whether that be through midterms or re-elections, or just public approval in general. That's the primary stopping force behind the president simply being able to act as they will, because there is the power of the people keeping the president in check.
The power of the people included a for-cause removal provision in the particular statute at issue.
I believe my time is expired. May I answer your question? Your Honor, we believe for-cause removal does exist. I would turn to my co-counsel's argumentation. However, to award reinstatement when reinstatement is not found within the law is to act outside of this court's power. And because this court shouldn't act outside of its power, we believe it should reverse. Thank you.
Thank you, counsel.
Counsel?
May I proceed, Your Honor? Counsel. Thank you. Mr. Chief Justice, Honorable Associate Justices, and may it please the Court. My name is Caleb Formo. My co-counsel, Mr. Park, and I represent the respondent, Mark Crosby, in the case at bar. My co-counsel will be addressing the remedy issue, but first, I will address the Article 2 issue. In Free Enterprise Fund, Chief Justice Roberts wrote of the lower court's decision stating that the removal issue was a question of first impression. Both he and Justice Kavanaugh specified that when there is no controlling precedent for a specific example, it becomes a necessity to look at the isolated variables and see if an exception applies. Today, we deal with such a case. There has never been an instance in this court's jurisprudence that will lead to such ramifications. It is because independence is a valid exception and the Federal Reserve needs independence that we ask this court to affirm the lower court's decision. Please.
Federal Reserve have enforcement authority?
Yes, Your Honor, we would agree with counsel for petitioner that there is some executive authority exercised by the Federal Reserve.
So you've conceded that he's an executive officer. Who's the head of the executive branch?
The head of the executive branch, as counsel for petitioner correctly pointed out, is the president. However, we do not believe that we are restricting the president's authority or his power by placing a for-cause limitation on him. The reasoning for that comes from Collins v. Yellen, a 2021 Supreme case, which ruled that disobedience is cause for removal. This was further emphasized in NLRB v. Electrical Workers, as subcited in Collins v. Yellen, which found that the legal principle that insubordination, disobedience, and disloyalty...
So what's the limitation then? So the president has to say, do A, and then the person does not A, and then the person can be removed?
The limitation, Your Honor, we would actually point to what counsel for petitioner brought up. Counsel for petitioner correctly pointed out that the centralized banking aspect of the Federal Reserve, that of these open market operations, is a quasi-private entity rather than the exercise of the executive power. Thus, they would be classified currently as an independent agency. Why that is important...
But what I'm struggling with, counsel, is you have a client who exercised some degree of executive authority. I understand it's complicated. The Fed has a bunch of other authorities, quasi-judicial, quasi-legislative, and it kind of looks like the First National Bank. But there's executive authority in there. So with respect to executive authority, it has to be that the president is in charge.
Yes, Your Honor, and we agree that the president is still in charge because it goes back to the fact that the president would still be the master of his house because all he needs to prove is the idea of insubordination, disloyalty, or this idea of disobedience. The standard is not that the Federal Reserve Chair needs to do something illegal in office, merely to
But how useful is that? I mean, to just be disobedient, to not do what the president says, that essentially eviscerates the idea of for cause. Wouldn't this just be going through the motion?
No, Your Honor, we would disagree because of what Collins v. Allen specifies. They specify that this disobedience is insofar as a legal order. The president, because as counsel for petitioner pointed out, interest rates are a private nature, cannot legally order the Federal Reserve Chair to change interest rates.
Wait. So almost all of the regulatory state statutes delegate authority not to the president, but to an administrative agency or to a secretary of a department or to a sub-official in the department, the National Highway Transportation Safety Agency, which is an agency within an agency, et cetera. Are what you saying is when Congress delegates the power to someone other than the president doesn't have the authority to control the decisions of that agency?
No, Your Honor, it is not our contention that the president has no control over the Federal Reserve. Rather, what we are contending is that there shouldn't be purely political fires when it comes to centralized banking. Yes, we would submit the claim that the Federal Reserve should be independent of political whiplash.
So you say the president has to prove disobedience, and I forget what the other Ds are. What is your vision for what that means and then what the court's role is here? I mean, to be sure, the firing here didn't come with the president saying, I think I have cause and this is why I think I have cause. Nevertheless, if a president did that, is that subject to trial then in a court?
No, Your Honor, our contention to that issue would be twofold. The first of which is in relation to the legal standard this court would be setting. We believe that this would be a strict standard because it's one this court already made in Collins v. Yellen, and it's one that this court has adhered to. But then secondarily, looking at the case at bar, it's not even stipulated by counsel for petitioner that their clients had cause. It is a stipulated fact that there was, in fact, no cause, and that the president just wanted to prove to the judiciary that they couldn't stop them. Thus, when in instance to the case at bar, this is not an issue. And going to the first response, this is not a legal issue in terms of jurisprudential doctrine moving forward.
What's the test? You know, we have to come up with a test, and we have to give the test to lower courts, and they have to figure out how to apply it, you know, the D.C. Circuit in particular. So there's disobedience on the one hand, and then politics on the other hand?
No, Your Honor, we do not believe it's as simple as disobedience and politics. Why it's important to understand that setting interest rates is not executive is because disobedience is in regards to the president giving a legal order to a subordinate and then them not fulfilling their responsibility to take care of.
Okay, so the legal order would be drop interest rates by 2 points.
Your Honor, that would not be a legal order because, as counsel for petitioner pointed out, setting interest rates is a private function, not an executive function.
So the president has no control over that part of the Federal Reserve's role.
We believe that in accordance to the First and Second Banks of America, we would submit that the claim that the president should not.
I don't understand what's happening here. Your friends on the other side are not urging us to overrule Humphrey's executor. But it seems to me that the necessary consequence of what you're saying here is that Humphrey's executor has to be overruled because the Federal Trade Commission isn't a purely private organization and never has been.
Your Honor, the standard that we are asking this court to make is not one of privatization. We do not believe simply because the FTC is not purely private, we need to overturn Humphrey's executor. Rather, the standard for independence that we are asking is twofold. First, an agency that has historic roots dating back to the founding, and second, one that has a pragmatic need for remaining independent. The first criteria is important because, as counsel for petitioner noted, the founder's intent is important in considering centralized banking. And then secondarily, the pragmatic need for independence further justifies that exception.
So what if the president gives an order to a member of the Fed that he doesn't particularly like, and it's something outrageous, like drop all of your enforcement actions today. That's executive, right?
No, Your Honor, because that would not be a legal order, because that would be quite literally illegal to say you should not prosecute something that is held.
Well, illegal under what? He's the president. He's the head of the executive branch.
Yes, Your Honor. And
He has
also-
discretion about what laws he enforces. There are a lot of laws on the books, counsel, that are not enforced.
Correct, Your Honor, but as the Take Care Clause notes, he does have the responsibility, the constitutionally vested responsibility, to take care that the laws are faithfully.
Okay, say he does it just about one case. I think this is a bad use of prosecutorial resources to go after Bank A in Chicago, and the Fed Reserve official doesn't obey. Can the Fed official be removed in that case?
I believe if it's referring to their executive power, yes, Your Honor.
Well, it is. Right.
Yes, Your Honor, for the prosecution, we believe that that is not an issue with the case at bar.
So if it's one, it's fine. But if it's all of them, no good. How about 50?
Your Honor, the right line that we are asking you to draw in terms of this 1 versus 50, we believe is one that is clearer than counsel for petitioner. The reason is the centralized banking aspect of the Federal Reserve. Yes, if he is asking them to do something executive and they disobey him, he does have cause for removal. That was enumerated in Collins v. Yellen. However, the centralized banking is something that the founders themselves recognized the need for independence, thus for-cause limitations are necessary. The very founders that counsel for petitioner claim would be opposed to such exception chartered the First Bank of America, which in the words of Baumzai and Nielsen writing for Cornell Law Review, mirrored the structure and the powers of the Federal Reserve.
Don't they say in that law review article that the law would need to be changed by Congress for the Federal Reserve to be immune from removability?
No, Baumzai and Nielsen do not specifically say that anything in the charter of the Federal Reserve needs to be changed. Rather, as I'm sure counsel for petitioner will argue, there are some insimilarities between the Federal Reserve and the First Bank, namely an increase in executive power. To that contention, we would submit two things. The first of which is that with this rise in executive power, so too was the rise in executive oversight. With the First Bank of America, the president did not get to appoint any of the officers. In the Second Bank of America, he got to appoint 5 officers and thus was able to remove those 5 officers. In the instant case, we see a Federal Reserve that is fully appointed by the executive branch and thus wholly removed by the executive branch. The second contention that counsel for respondents would submit is the idea that it is irrelevant to the case at bar as to whether the Federal Reserve has the same powers as the First and Second Banks, because the important aspect is the founders' desire for centralized banking and monetary policy being independent.
Okay, that's helpful, but I'm still bothered about something I asked about earlier. So how do we stop a president who disagrees with the Fed's open market policy, interest rate setting policy, from coming up with other reasons that are formally executive to get rid of the person he or she doesn't like? Because it's pretty easy, right? You could come up with something and say, do A, and you know the Fed Reserve person is not going to do A, and then you kick them off. And we all know it's because a disagreement on monetary policy.
Chief Justice, it appears like I'm all out of time. May I address the Associate Justice question?
He doesn't have to. I was just getting something off my chest.
But I want to hear the answer.
Okay, please answer.
Just a sentence or two.
Yes.
Thank you, Your Honor. To that concern, we would submit the claim that it is up to this court to exercise its discretion because this is a case of first impression. If he is simply using political whiplash as justification, that is what counsel for respondents are protecting against. Counsel for petitioners' claim is that the Federal Reserve should be subject to political politics. Thank you.
Hey, Kels.
Counsel.
Your Honor. Thank you. Mr. Chief Justice, Honorable Associate Justices, and may it please the court. My name is Harrison Park, and today I'll be addressing the remedy issue. A law without enforcement is no law at all. The for-cause removal protection statute means nothing if it cannot be enforced by law. The legal right that was violated in this case is Chair Crosby's right to his position. where there's a legal right, the court has the authority and the responsibility to provide a remedy whenever that right is violated. It is because the only remedy that can be provided in the instant case is reinstatement that I ask this court to affirm the lower court's decision, issuing that a writ of mandamus is in fact within this court's legal jurisdiction and that it is constitutional. To this end, we offer 2 points of argumentation. First, that the requirements for a writ of mandamus are met in the instant case, and second, that a writ of mandamus may be issued directly against the president. To the first point of argumentation, counsel for petitioner argued that in order for a writ of mandamus to be issued, there must be a ministerial duty. Now, we understand that a writ of mandamus is an extreme remedy, not likely to be passed in every single case, and we would agree. It is a very extreme remedy that is provided by this court. But the requirements to be met are also very high. In order for there to be a writ of mandamus to be passed, there must be a ministerial duty.
Counsel, though, how do you respond? So I see there are 2 real ways of framing this, right? You can look at your client being entitled to, having a right to finish their term, and if that's the right that's been violated, and so you need to reinstate to give any remedy. But your friend across the aisle talks about it as well. He was, he was removed from the position. So what's the remedy for removal? How is that reinstatement? Once you're removed, like that already has happened. You can't take that back. So which framing is right and why?
Yes, Your Honor. And I believe you're referring to counsel petitioner's argument that there is no ministerial duty because there's no peremptory obligation created by statute to reinstate Crosby. And to that, we turn this court's attention to Marbury v. Madison, which held that it is true that the mandamus now moved for is not for the performance of an act expressly enjoined by statute. However, it has already been stated that the applicant has that commission a vested legal right from which he is not removable at the will of the executive. This then is a plain case of mandamus. Quote. In other words, this court held in Marbury v. Madison that although reissuing that commission was not established by statute, it was implied because of the vested legal right that was violated in that case. We also believe that counsel for petitioner's definition of a ministerial duty is slightly blinding in the sense that, according to this court of Mississippi v. Johnson, a ministerial duty is simply one that does not require discretion. The instant case, according to the facts of the record, the statute that was broken was the for-cause removal protection statute, which stated that absent cause, removal was not available.
Counsel, why would we issue an extraordinary remedy when we have an ordinary one? Back pay. Pretty easy.
Your Honor, we believe that as Associate Justice Keller asked in counsel for petitioner's argument, to issue back pay here would not truly look at the issue that is presented at hand. As Associate Justice Keller pointed out, the person's position is worth more than the reparations, the financial reparations that the position is worth. Thus, simply providing back pay doesn't provide a legal remedy.
Yeah, but you're thinking in terms of the American regime and separation of powers. But your client is made whole by back pay. So what else is there to do here? I mean, that's a lot of parties don't like just getting damages. They want something more. But if damages make them whole, we're done here. We have limited authority.
Your Honor, we would argue that pursuant to Marbury v. Madison, a person's position is worth more than the money that it is worth. So simply providing back pay wouldn't, to use your words, make him whole because he still has a legal right that was violated by the statute. Providing back pay in the instant case is not sufficient to remedy the right that was violated. The only cases where back pay was sufficient in the examples of Humphrey's executor were because during the time of the litigation, Humphrey had
Given the legal right to that position.
I apologize, Your Honor. Could you rephrase the question?
Yeah, what you said that your client has a legal right to the position. What is the source of that right?
Because, Your Honor, Chair Crosby was appointed to that position and was wrongfully removed, and President Bronner failed to comply with the for-cause removal protection.
I'm asking what the source of the right is. Is it the Constitution? Is it natural law? Is it a statute?
We would argue that it comes from statute because pursuant to Marbury v. Madison, it states that once a person is appointed, that right becomes, in fact, his property. It's a vested legal rights that came to him once he was appointed and was violated through non-compliance of the for cause removal protection statute. We would argue that pursuant to this court's jurisprudence, when there is non-compliance with a clear ministerial duty, as there is in this case, then the court may enforce performance of that duty.
So the ministerial duty is the president's requirement to state that the president has cause?
Your Honor, the ministerial duty at hand is that the president may not remove a member of the Federal Reserve Board absent cause.
I think that, I mean, Marbury versus Madison, while it says not a statutory requirement, is nevertheless still of the view that delivery was required following appointment and sealing and signing the commission, et cetera, right? Not, but you're phrasing this in terms of a negative duty. Is that correct?
To some extent, Your Honor, yes. Did you have a further question, Your Honor?
So wouldn't, in addition to back pay, the issuance of a declaratory judgment satisfy the full relief here?
We don't believe so, Your Honor, because declaratory relief is not binding, and thus the president has no obligation to comply with the court's declaratory relief. The only case we have within our jurisprudence where declaratory relief was in fact sufficient was in NTU v. Nixon. And the reason why NTU v. Nixon is not applicable to this case is because the only reason they issued it in that case was because he failed to meet a deadline, not because the president explicitly tried to authorize himself above Congress. So we have no reason to believe that if this court were to issue declaratory relief, he would comply with that order and reinstate Chair Crosby. Thus, we believe
The council, what about, declaratory relief that says the president wrongly terminated you? I mean, and that you were entitled to it, but because politics, you cannot complete that term. I mean, it doesn't have to be relief say, we must reinstate him even as declaratory.
Your Honor, to answer your question, I have two responses. The first of which is that, again, declaratory relief does not enforce compliance with the law, and thus we have no reason to believe that simply because this court makes a statement that there will actually come any result from it. Furthermore,
So what the result could be is impeachment proceedings. It could be the Senate refusing to confirm a replacement or any replacement until the president nominates someone who is similar or renominates the person, renominates your client, right? So when it comes to enjoining the president, if we declare rights, shouldn't we just leave it to ordinary politics? And we can declare rights either through back pay awards or through declaratory relief.
I don't believe so, Your Honor, for the sole reason that pursuant to this court in Kendall v. United States, ex rel. Stokes, it was essentially decided that the court was a coextensive of the legislative, and thus they were meant to enforce the decisions of the legislative decisions of Congress. And we would
Political question doctrine seems to say there are certain circumstances that we should step away in enjoining the president. But let me ask a broader question. You frame your argument around this principle that for every infringement of a right, there should be a remedy. Many of our state constitutions have such a provision, but the U.S. Constitution does not have that proposition in it. Where is it rooted in the Constitution, or what's the source of reliance for that proposition?
Your Honor, we would turn to the take care clause that the president must faithfully execute the laws. Again, we'd like to bring you back to the introduction where we stated that unless a law can effectively be enforced, there's no purpose for that law.
We have long said that we cannot order the president to bring a prosecution. The president decides to dismiss a criminal case. We have no jurisdiction to enjoin the president to continue a criminal case, continue a civil case. There are all kinds of things that might be construed as take care that we don't get involved in.
Your Honor, I understand that this court's jurisdiction is limited in the sense that we do not want to disrupt the principle of the separation of powers doctrine. However, if this court does not respond in a matter of Chair Crosby's rights being restored to him, essentially the president is being put above the law, and the court is stating that the president, essentially there's nothing that can enforce the president to comply with the law.
Are you asking us to overrule In re Sawyer?
No, Your Honor, because we're not complying with the courts of equity. A writ of mandamus comes out of courts of law. This was a principle established and understood by counsel for petitioner, so we do not believe that In re Sawyer has jurisdiction in this case because we're talking about the powers of law. We do believe that because the requirements of a writ of mandamus are met today, that
So, isn't there a remedy that can be granted? I mean, yes, seeing that we have the power to, and that your client could be put back in his chair position, he would then be serving at odds with the president. Wouldn't that eliminate a lot of the authority he would have had as Fed chair? Meaning that the remedy that you're asserting would not actually grant him relief either. Isn't that the case? And if not, why not?
none are two sets. Thank you, Your Honor. The reason why this is a remedy, Your Honor, that is sufficient is because there is no other remedy that would restore the right that was violated in the case. Even if in some cases his performance is in fact limited, it restores the rights that was unlawfully taken from my client today. And then thus, because the court has the authority to provide this relief, we ask this court to affirm the lower court. Thank you.
Did petitioner reserve cause? Yes.
Your Honor, counsel petitioner got nervous that you're about to serve time. They have 3 minutes of unused time they would like to use for rebuttal, of course. Thank you, Your Honor. Mr. Chief Justice, Honorable Associate Justices, and may it please the court. First, to the Article 2 issue. The primary argument that counsel for respondents made rested on the idea of Collins versus Yellen. They claimed that this court stated that disobedience constituted cause under the law. We would disagree with that reading of Collins for 2 primary reasons. First, the court did not hold that disobedience constituted cause, but rather speculated that it might. There was no standard or no definitive ruling within Collins on that issue. The second is that the very next sentence within Collins states that disobedience being cause isn't enough. This is from Collins versus Yellen, page 32. This court wrote, "The president must be able to remove not just officers who disobey his commands, but also those he finds negligent and inefficient, those who exercise their discretion in a way that is not intelligent or wise, those who have different views on policy, those who come from a competing political party who is dead set against the president's agenda," end quote. Now, let me clarify. That standard set forth in Collins is a very drastic, not one that the petitioner is absolutely advocating for. Simply, the argument that we're making here is that counsel for respondent did not accurately interpret what the court wrote into Collins, because they specifically stated that allowing these individuals to be removed just for disobedience wasn't enough to justify the argument that counsel for respondent is making. To the idea of reinstatement. Now, the counsel for respondent
If we look at your argument and take it to its logical extreme, doesn't that mean that the president of the United States could say, okay, you person who handles the mail at the Fed, or you provide janitorial services, both important things, but not really executive power-related things, that he could fire them?
I would disagree, Your Honor, on the merits of that question. First, those individuals, as you pointed out, would be building good power, and thus we use them that rule. Second, those individuals at most would be inferior office, and thus they'd fall under the more generous rules and exception, rather than being touched on by this word in its precedent. To the reinstatement issue. Counsel for respondents pointed to Marbury versus Madison as an example of where a mandamus could be used in this particular case. But as Mr. Chief Justice pointed out, the case in Marbury was that of completing the law, not that of writing a law that hadn't written. The individual Marbury in that case had been assigned his seat, but that assignment had been denied, and therefore the mandamus was used to complete the law. It's entirely different from facts at hand, where the law has already been violated, and counsel for respondent is asking this court to write a new law requiring reinstatement. That is why ultimately stand that's the lower court's issue. Thanks, counsel.
The case is submitted.
be waiting for you outside for pictures.
Yes. One way to sit, because I might have